Hi, my name is Pardis Madavi, and I'm the Dean of Social Sciences and the Interim Director of the School of Social Transformation here in the College of Liberal Arts and Sciences at Arizona State University. On behalf of the college and all of Arizona State University, I want to take a moment first to thank you so much for joining us for one of our most important signature events, the annual John P. Frank Memorial Lecture. This lecture is a point of pride for the college and for the School of Social Transformation, as John P. Frank and his legacy stand for so much of what Arizona State University's charter about excellence, inclusion, and justice are really about. Today, you're going to hear from Neal Katyal, a very important conversation about above the law, seeking justice, and the 21st century Supreme Court. I can't think of a more important time to have conversations about justice, the law, and the role of the courts and the role of arguments in pursuit of justice have to contribute to our society. As our society tackles some of the most pressing and wicked problems, it's conversations like the one that you're about to hear today that can help us solve these pressing problems that face all of us worldwide. Thank you so much for joining, and welcome.
Good evening. I'm Madeline Edelman, Professor of Justice Studies in the School of Social Transformation at Arizona State University. Our school, perhaps the most diverse academic unit on campus, which we call SST, is made up of several autonomous and interlocking units. All of us conduct research on, teach about, and engage in professional and public service related to various forms of inequality and pathways to justice. We wish to note that at SST, we work on the ancestral homelands of indigenous tribes that have inhabited this land for centuries, including the Acamel, O'odham, and Peepash peoples. I also would like to thank Jeannie Colquette, Enrique Martin Palacios, James Salisbury, and the rest of our staff for their expert collaborations, especially during COVID and our move across campus. One logistics note. We welcome you to submit questions to our guest speaker during this live stream event by using the chat function of our YouTube channel. If you're watching this event on ASU Live, welcome to you as well, but you may want to switch over to YouTube if you want to submit a question. You can find us there by searching for the School of Social Transformation. This evening, we gather to champion the legacy of John P. Frank. John Frank was a lawyer, constitutional scholar, historian, and the author of 11 books, including a biography of Justice Hugo Black, for example, for whom he had been a clerk. He was a generous advisor to Anita Hill, for as another example, during the Clarence Thomas Supreme Court nomination hearings. She was our guest speaker in 2018. He also was an effective mentor within the legal profession to people of color and white women. For example, to Secretary Janet Napolitano, who was our guest speaker as well in 2010. Over the course of his long career, Frank was influential in shaping public policy in Arizona and in the United States. He helped shape the argument in the landmark Brown versus Board of Education Supreme Court case, and he took the Miranda case all the way to the Supreme Court. John Frank advanced critical First Amendment, labor, and desegregation cases. Extending his legacy in SST, we prepare our graduates to analyze entrenched social problems and break boundaries in order to create a more just, democratic, inclusive, and equitable society. I've had the pleasure of serving on the John P. Frank Annual Memorial Lecture Committee, which includes members of John Frank's family, colleagues, mentees, and friends, as well as faculty and staff from the School of Social Transformation. I'd like to thank Susan Freeman for her role this evening as conversation partner for our guest speaker, Neal Katyal. We are honored to serve as the home for this signature event and invite you to enjoy our program.
Good evening. I'm Gretchen Frank, and on behalf of the Frank family, I welcome you to the 22nd John P. Frank Lecture. This has been a remarkable series which honors our father and the principles of justice to which he dedicated his life. I'd like to thank Madeline Edelman and the committee, some of whom are among my parents' dearest old friends, for keeping this project alive. Thank you, too, to those who have recognized its importance by contributing to make it possible. My daughter, Eva, a proud graduate of the School of Social Transformation, and I were talking about who might be a good choice for this year's lecture. In past years, we have tossed around several suggestions, but this year I knew just who I hoped it might be. Let me tell you why. Neal Katyal epitomizes someone who walks in my father's footsteps. In his already prodigious career, he has grappled with many of the same issues that were important to John: death penalty, voting rights and suppression, internment, and the need for more pro bono work among them. I am not a lawyer. I admit that I didn't know about Neal Katyal until we started to live through the nightmare of the past 5 years. I became familiar with him from his appearances on several of the news shows I depend on, sort of backing into learning about the 40-plus cases he has argued before the Supreme Court. I read his book on impeachment and was madly encouraging others to do so before the first impeachment trial, finding it so valuable. I started listening to Courtside to help make sense and understand more deeply what was happening on a daily basis. Neal Katyal was not the only voice I turned to during those years. I don't know about you, but for me, the more information I could get helped to bind the anxiety I felt for our country and to feel a bit more in control. Sometimes I wondered if I would ever read just for fun again. There were many, many days when what I wanted was to talk with my father. What would John say? Has been a recurring touchstone for me. But now, when there were particularly enraging or frightening days, I noticed myself thinking, what will Neal say? Why? Neal Katyal is a teacher. This is another public service he performs. He doesn't just talk to his legal peers, but translates so that other citizens can be well informed. I'm very grateful for that. He is a resistor at the highest level. He is a fighter like John Frank was. It gives me hope to know that the kind of work my father did is carried forward by an intellectual powerhouse like Neal Katyal. Both of them are guided by their commitment to leave the country better than they found it. Mr. Katyal will be in conversation with Susan Freeman tonight, which is another special pleasure as she is a partner at Louis Roca and someone particularly dear to my father. Thank you, Susan. Thank you, Neal, for participating, and thanks to everyone for attending the event tonight.
I'm Susan Freeman. I'm a longtime partner at Louis Roca. I started with the firm in 1975 and have spent my legal career here. John Frank was my partner, my teacher, my mentor, and my friend. I'm deeply honored to participate in organizing and presenting this annual lecture as a tribute to him. Professor Neal Katyal is our featured guest for this year's John P. Frank Memorial Lecture. We are so pleased to have him join us to engage in a conversation we've entitled Before the Law, Seeking Justice and the 21st Century Supreme Court. As some of you may know, Neal Katyal served as acting Solicitor General of the United States during the Obama administration. He has orally argued 43 cases before the Supreme Court of the United States, with 41 of them in the last decade. At the age of 50, he's already argued more Supreme Court cases in U.S. history than any other minority attorney, breaking the record of Thurgood Marshall. He also served as in the Deputy Attorney General's office at the Justice Department as National Security Advisor. He's a law professor with more than 2 decades of experience teaching constitutional law, criminal law, and intellectual property at Georgetown, where he also serves as the faculty chair of the Institute for Constitutional Advocacy and Protection. Neal has also been a visiting professor at both Harvard and Yale Law Schools. Last summer, he presented a TED Talk entitled How to Win an Argument at the Supreme Court or Anywhere. It has garnered close to 1.9 million views and counting. And at the same time, Katyal runs one of the largest Supreme Court practices in the world, Hogan Lovells, where he occupies the role formerly held by now Chief Justice John Roberts. Neal Katyal is also an author of the recent book, Impeach, the Case Against Donald Trump, and he hosts 2 online series, Courtside, an episode series on IGTV, where he explains Trump's post-election litigation, and The New Normal, which is an occasional salon that focuses on COVID life. You may be familiar with his regular commentary on MSNBC. We are particularly grateful to have Neal Katyal with us today because he's now serving, as we speak, with the Minnesota Attorney General's Office as a special prosecutor in the Derek Chauvin case. In short, Mr. Katyal is the definition of a public intellectual and reflects the values and habits of John Frank, whom we celebrate this evening. So, Neal, coming up, yes, we have developed some questions for you related to some of the most critical equity and justice issues our legal system faces today. We also have questions submitted by the public, and we'll have time for additional questions being submitted live by attendees to YouTube. So let's start with the commission. Speaking of the 21st century Supreme Court, President Biden has just created a commission to study possible changes at the court, including term limits and the expansion of the number of justices. I understand the number has changed 6 times until settling at its present number of 9 in 1869. And the majority of Supreme Court justices right now are pretty conservative. So what do you see as the advantages and disadvantages of expanding the court or attempting to eliminate lifetime appointments or whatever else the commission might study?
Okay, well, first of all, I just want to thank you, Susan, for that very warm welcome, and to thank Gretchen as well, because that was remarkable to hear that. I don't think her father would have agreed with what she said, but it is incredibly sweet of you, Gretchen, to say that. And John Frank is a hero to us all. You know, if anything I do in my career approaches even 1/10 of what he did, I'd be a pretty happy man. So Susan, you asked about President Biden's commission to study court reform. And I think it's a good idea to have some sort of commission study it. I do wonder with 36 members, what can get done. You know, and I like the fact that there's a lot of intellectual diversity on that commission, but I do wonder whether it's just possible at all for them to agree on anything, or if it's just going to be a kind of compilation of different views, which we kind of already know. So, you know, I really hope at the end of this, they can forge some sort of agreement on some things, but, you know, that may be hard. You know, I started this by thinking that the Republicans in the Senate have monkeyed around with the Supreme Court in really horrific ways. And, you know, my starting point for that was in 2016 when Justice Scalia passed away in February and Merrick Garland was nominated. And you know, President Obama could have nominated some radical person, but he did the opposite. I mean, he put like really the nation's most centrist, well-respected judge around. Merrick Garland at that point had been the chief judge of our nation's second highest court for more than a decade. He'd been a judge for 20 years, never been reversed once by the Supreme Court in 20 years. I mean, extraordinary. I mean, you know, loved by liberals and conservatives on the court alike. So, you know, to not even give that man a hearing, I thought was just beyond the pale. And, you know, and then the most recent, you know, set of events when Justice Ginsburg passes away just before the presidential election. And the same people who said, oh, we don't have to fill a seat if a justice dies in February because there's a presidential election coming up and it should be a referendum on the seat, then turned around and said, oh, we absolutely have to fill the seat in 14.2 minutes, which is what they did. So I think there've been a lot of games played here. And, you know, I love the Supreme Court. I mean, you, Susan, I know you've argued there. And, you know, it's just it's a remarkable institution, but it's an institution that is going to have a breaking point at some point if all of these political games are played. And so I do think something needs to be done. I don't think that the court in the way I don't think that the court, you know, given everything that happened, does have the same type of appearance of legitimacy as it should. And that's a really unfortunate thing. So, I welcome the commission. I think it's a good idea to study this and to open up that conversation also to lower courts and to think about, whether things should be done there as well.
So we know you can't talk about the Chauvin case in particular, but the concept of aspiration for racial justice in the US weighs heavily today in a variety of legal spaces. Where do you see efforts towards seeking racial justice gaining the most traction? Or where do you see the greatest opportunities for seeking racial justice?
So this is a place I am pretty optimistic. You're right, I'm not going to talk about Chauvin, so this answer shouldn't be interpreted in any way about that. But I do feel like as a country, over the last year, there's just been so much more widespread attention to what African Americans face, and now more recently with what Asian Americans face in terms of brutality and some of the systemic barriers that minorities face in this country. And I do think that there's just a more open conversation. I know, Lewis and Roca's had it, Hogan Lovells has had it in ways that, in my last 8 years at the firm, I didn't have those conversations and they weren't these kind of real grappling with where society is. It was easy to, do your pro bono work and other things and care, of course. But now I feel like it's much more central to the mission of what being a lawyer is all about, indeed, what being a citizen is all about. And so I never, I think race was in some ways more politicized before the last year and a half than after. I feel like there's some bridges that are being built here and some opportunities for, whether you're conservative or liberal, you can stand up and say, this is just detestable, what's going on in terms of, whether it's discrimination or over criminalization or whatever. And so, I'm actually feeling pretty optimistic right now that we're on the path to moving in a better direction. One place I do think that's really important that we do continue our efforts is affirmative action in colleges and universities. I think that by bringing people together from different walks of life, that is what a university does at its best. And it's not just about race. I think it's about geography. I think it's about, socioeconomic status. I think it's about so many different things. But I think if we can think of the university as a place to incubate and learn from one another, as opposed to just, revere our existing positions, I think that that's a really important function and a path to moving society in a better direction. And one thing I am concerned with on campuses today is that people tend to talk to only those who they agree with. I think faculties are also somewhat that way, or in some cases very much that way. And if you're a real true believer in diversity, it can't just be about race. It's got to be about the way in which people think as well. And we need to come back to this idea of the university as a place where our ideas get challenged and speech runs rampant in a good way, not in a hurtful way, but in a good way.
You mentioned decriminalization. Arizona is one of the top 5 states for incarceration rates. We also have one of the lowest levels for funding of public education. Some link there, I think that matters. Could you talk to us about your views on criminal justice reform?
Yeah, I think this is a place in which I feel very optimistic about the future, in part because we're in such a bad place and have been for so long. So we only really can go up. But I do feel like there is opportunity for conservatives and liberals to come together. Take, for example, this practice of cash bail. The idea that when you get arrested, you get thrown in jail and you're not allowed to go free unless you can post a certain amount of money. And, in our society, yeah, sure, money matters for things like can you eat at a fancy restaurant or not, but it doesn't matter for whether you should go free or not. That should turn on really, whether or, whatever crime you committed, how dangerous it was, and your likelihood of fleeing. And turns out actually posting a cash bond has very little to do with whether or not you're likely to come back. or not. And so I think many states are now rethinking this whole practice of cash bail. Illinois, got rid of it entirely. Other states are, thinking about different solutions in this area, or at least reducing the amount of money that's necessary. So I'm really glad to see that. I'm glad to see things like decriminalization of cannabis, which has, enormous racial effects. So I think we're moving in the right direction. And you're right to say that part of this does unfortunately stem to, basic structural things in society, like which schools are being funded and which aren't. And, it's the worst investment in the world to try and skimp on education because, ultimately society pays those prices later on in terms of higher crime rates, incarceration rates, and the like.
Our legislature would pay attention to that. Okay, so let's turn to hate crimes. That's another part of criminalization that really matters now. What we categorize as hate crimes really have a significant impact on targeted communities beyond the victimized individual or damaged property. And recent news suggests widespread nature of these bias-based crimes in the US. What do you make of the tension between sentencing enhancement, which is the primary remedy for hate crimes legislation, and the push for criminal justice reform? Are you optimistic about that too?
Well, first of all, one thing I am optimistic about is the way in which I think more people in society are appreciating what a hate crime is and how corrosive it is to the community. And I have to say, I grew up as an Indian kid in Chicago, and some horrible things happened. And some of them weren't crimes at all. Things like a woman yelling at my mom who's in the car, "Go back to your country," and things like that. But some were. A cross was burned on the other Indian family's lawn. I don't know if the races can really, keep it straight between African Americans and Hindus and the like. But in any event, I just remember things like that, and I'm sure other people have any number of stories about this. And we were just told, kind of, walk away, don't make a deal of it. You're going to get in trouble if you did. And we were little kids, so that's what we did. But I feel like now people appreciate that when that cross is burned, when that person is beaten up, it's a crime not just against that person, but a whole concept of what America is. At its best, our vision of what the country is about is you come land on its shores from whatever place you are, and you're an American. E pluribus unum is our national motto. Out of many come one. That's the idea. And when you have people do this, it tears at that whole vision of what America is. And just to digress for a moment away from hate crimes, I'll come back to hate crimes, but tearing at that vision right now are these comments by Tucker Carlson, which he's done over the last few nights, saying basically the Democrats are trying to bring immigrants and foreigners to the United States so they'll gasp vote. Oh my God. Frankly, that's what the whole country is based on. Everyone, outside of Native Americans who actually, if anything, have, I think a more powerful rejoinder to Tucker Carlson than I could ever have. But, the whole idea is, of course, we want people to come here and become citizens and to vote and pay taxes and fight for our government and fight for our people and, take productive jobs and the rest. And, I do worry that we're increasingly becoming a world in which one political party is so at odds with what America actually is. They're no better than, Brezhnev or, Khrushchev or someone like that. They're fundamentally anti-American at their core. And, it doesn't matter what your name is or what your skin color is. It's actually, to be an American, I think you have to embrace the founding ideas of what the country is about. And, like e pluribus unum. And if you don't have those, absolutely, you've got your right to speech, 100%. but I definitely don't think that you have a lot of credibility when you stand up and talk about the Constitution and its values and you being a strict constructionist and all the other garbage that we hear out of that gentleman's mouth. So, okay, now to go back to hate crimes for a second, you asked a very specific question, which was whether or not I thought that there should be sentencing enhancements for hate crimes. And, is that in tension with criminal justice reform? I don't think it is. I mean, criminal justice reform is not a, defund the police and let everyone go for any crime. That's certainly a caricature of it. It is an idea that certain things are over criminalized and certain things may be under enforced as well. Hate crimes is an example in which I think there's, if anything, been under enforcement of those. So I don't have any problem with enhancing a sentence if someone commits a crime of hate, because it's actually a different crime. It's a different thing to beat up a person and just beat them up, not to condone it, but just to say that, that's, that kind of quote simple assault. And another thing to carry out that very same assault, but at the same time, uttering words of hate. One makes it a crime against the individual, the other makes it a crime against something larger. That whole conception, it's a crime against the community, but it's a crime against fundamentally America and its values.
Okay. Speaking of fundamental American values, let's turn to religious liberty, because we've seen a rise in the kind of right to discriminate cases that are moving through the courts, especially when it comes to LGBTQ rights. Where do you see the strengths and weaknesses of legal theories, of the kinds of arguments that can be made in these cases?
Yeah, so this one's also like the Derek Chauvin one, a little hard for me because I have the kind of, I think, main case on this before the Supreme Court, which I argued in November. It's called Fulton versus City of Philadelphia. And what happened in the case is that Philadelphia, like many cities, has, and I'm just going to describe the public facts and not do anything more than that, but just so that everyone listening can understand really what the issues are and what the court's grappling with. So the city of Philadelphia, like many cities, has foster care programs, and it basically has tapped 30 different private agencies to carry out foster care, screening of potential parents and the like. And it's been running that program for a long, long time. It learned through a newspaper article that 2 of those 30 agencies would not let LGBTQ parents be foster parents. They just said, we will discriminate against you. It's against our religion. And the city looked at it and said, well, we are truly the city of brotherly love. We have a deep commitment to equality. And we can't have people who are carrying out city functions discriminating, even if it's in good faith based on their religion and so on. So they said to those 2 agencies, look, we have a non-discrimination policy. We've had it for decades, and we can't allow you to discriminate. Well, one agency said, one of the 2 said, okay, we'll, take everyone and, we'll treat everyone equally. The other agency said, oh, nope, we have a right to discriminate, and it's our constitutional right. And they went and sued the city of Philadelphia and insisted that they had a right to a government contract that allowed them to discriminate. So, we came into the court case to represent the city, and we basically, this is a tension between equality and religion, but it's, in many ways, in my judgment, not one that is impossible to reconcile. It's one thing, nobody's forcing these agencies to operate, and if you operate, it seems to me, you operate under the conditions that the city lays down. So it'd be one thing if the city was saying to people, you must do X, but that's not what the city's saying. The city's saying, look, if you want a government contract, which we don't have to give to anyone, but if you want it, then you got to obey our equality rules. So I feel like it's a different case than, some of the other ones that have come, like the question about can, a baker be forced to bake a cake for a gay couple, which is a case called Masterpiece Cake Shop a few years ago, in which the government is kind of directly regulating private behavior. This is one in which people are voluntarily saying, hey, I want that government contract. Well, if you want that government contract, there are all sorts of terms of the deal, just like you gotta, serve this number of foster care parents and foster care children or any number of other things. So this is just, in my judgment, just one element of the deal. So the court that has that case pending now, I suspect we'll get a decision, sometime in the next month and a half, something like that. In that case, they've also had these emergency motion cases, which haven't yielded any oral arguments or full opinions, but they come up usually like on a Friday night. So like the latest one, which I've been too busy to really understand the facts of. So, please don't take these facts as literal, but as I understand it, California had rules that prevented people from congregating, whether or not it was a private barbecue or a private or religious ceremony. They had the same set of rules. And so they didn't do what like some jurisdictions did, which would say religious ceremonies can't occur or can only occur with fewer number because there tends to be singing and other things that spread coronavirus more. They just treated everyone equally. And the Supreme Court, as I understand it, and again, I haven't even read the few words that the court wrote, which I think are mostly a dissent by Justice Kagan. But as I understand it, the Supreme Court in a 5-4 decision said California's restrictions were unconstitutional because it discriminated against religion. So I do feel like, that there's a concern that this court may be so solicitous of religion that it runs up against other very deep commitments to public safety, to equality, and the like. But we'll just have to see. I think we're going to have a much better picture of where the court is by the end of this term.
Thank you. So let's turn to a different perspective. Pew Research suggests that public trust in government is hovering at an all-time low. The data also showed that the majority of Americans want the federal government to play a substantial role in addressing entrenched social problems. So if you were in Merrick Garland's shoes, what would you prioritize in terms of rebuilding the Department of Justice from the inside, while also rebuilding public trust in our government institutions more generally?
Well, I think that Donald Trump spit on the Justice Department, and the Justice Department is like one of the crown jewels in our democracy. And I can't tell you what a privilege it was to work there both times, because what I saw both times, and I remember coming in much more politically like we should do X, we should do Y. And both times I just listened to the career officials there and learned why the department takes the positions it does, the way it approaches things, and really concluded my instincts were totally wrong about the department and what I thought was right. I think it works because it doesn't operate politically. I think it works because the Department of Justice leadership has understood that what the United States' interests are don't vary much from one administration to the next. They stay consistent. And so, when I ran the Solicitor General's office, I actually didn't deviate from the positions taken by the Bush administration. They were very centrist positions. And indeed, only in one case did we wind up deviating, and that required a decision by President Obama to do so. The Donald Trump Justice Department, by contrast, flipped positions from predecessor administrations like candy. I mean, I think they did so 43 times or something in the first year alone, compared to like once in 4 years with Obama or something like that. So it's like remarkable, and did so in any number of incredibly despicable ways. Like, take, for example, the case pending now at the Supreme Court about the Affordable Care Act. There's arguably a tiny flaw in the act as it's now in existence. And what the Trump administration did is they said, well, that flaw exists, we concede it, and that flaw means the entire Affordable Care Act gets struck down. What we'd say is no severability, to use the lingo of lawyers. Now, the Justice Department is not in the business of going and trying to seek the invalidation of federal laws. To the contrary, your duty as Solicitor General is to defend federal laws. These guys came in, and I do say guys, and just used the department as a sword to try and strike down any legislation they didn't want. It was preposterous, and a total disrespect for the oath that they take to serve at the Justice Department. And so I think to return to your question, what can Merrick Garland do? The first thing is a top to bottom review of what the Trump administration did. And don't invalidate something just because Trump did it. I mean, that's what, Trump did to Obama in all sorts of stupid ways. But understand what is the long-term interest of the Justice Department. What did the prior administration say about a particular issue? Be informed by that and then make a decision. And so we're starting to see that process unfold now, and I think it's looking good. And so, I think it's typical Merrick Garland values. It's deliberate, it's thoughtful, it's not a rush, it's really careful. So that's number one. Number two, and these aren't in order of priority, they're just as they're coming to my mind. January 6th. I don't know how we get past those events without a comprehensive report as to what happened, including what the Trump administration did there, but also Congress, what individual members of Congress did, what militia groups
Arizona's members of Congress who took people on tours the day before.
Yeah. So, all of that I think has to be looked at, the role of these different militia movements and the like. Why, still to this day, I don't understand how so many people were let go. Like, oh, no big deal. You broke into the Capitol, you smashed in, with weapons and other things, and then you're just let go. I can't figure that out. I can tell you in the Black Lives Matter protests in the summer before, they arrested, hundreds of people. But here it seemed like everyone was let go except, 20 people or something. And then they start having to ID them because a lot of these jokers, started bragging about it on social media. So yes, you got some people that way, but why were they let go in the first place? I just, can't even begin to understand that. So I think we need a real comprehensive accounting of that, but then also a kind of understanding of how rhetoric by our nation's leaders contributed to this. I'm not saying it's necessarily a court case about incitement or something. It might be, depending on what the evidence shows. But it is not behavior that, this is not politics. This is not a political point. This is just that's not American behavior to say the kind of stuff that Donald Trump said. And I think we need to take it out of the realm of politics and just say, if it were the other party and they acted this way, would you really be defending this and saying, no big deal and so on? Of course not. Of course not. And so, in my impeachment book, I talked about a principle that I've used in basically everything since my first day of law school, which I just call the Yardstick Rule, which is, and it's what your law professors say on the first day, which is, look, we all come in with biases, and the best way to understand whether your intuitions are correct and the strength of your argument is to play the other side or reverse the identity of the parties. So, if you really think that what Donald Trump did was okay, just pretend it was said by Biden or Obama and ask yourself, would you really think it's okay? And I think that flipping of yardstick is such an important way, like the fancy philosophical terms are behind the Rawlsian veil of ignorance, but it's just a simple idea that we all are influenced by the identity of the parties, of who's saying what. And so just try and ask yourself in your mind, flip it, and do you still have the same results, same preferred outcomes?
Let me turn to the right to vote and Senator Warnock recently brought in from Georgia, described that as sacred. Can you talk to me about the concerns raised by the Arizona case that's pending in the Supreme Court now about ballot harvesting and voting in another precinct, and this trend of voter suppression bills that's pending in Arizona and other places around the country?
Yeah, I do think that speech by Reverend Warnock, Senator Warnock, was so incredible. I mean, and it's worth everyone watching. This is linked to some of the kind of corrosive elements that have unfortunately happened in the Republican Party. This new one, which is just basically anti-voting. I kind of can't really get my mind around how this party got there, because I had the privilege of defending the Voting Rights Act case in the Supreme Court in 2010, right after President Obama was elected, and that was passed in 1965 with the blood of patriots on it, people like John Lewis who marched at the bridge and so on. And in the course of researching that, I looked at the different votes for the Voting Rights Act in Congress. The last time it had been authorized was in 2006, and it passed unanimously in the Senate, and I think it was like 421-3 in the House of Representatives. That is to say, everyone basically 100% agreed, or very close to 100% agreed, that we needed federal law to protect against discrimination in voting, and very aggressive forms of measures of federal law, a pre-clearance regime and things like that. And now we're in a world in which, places like Georgia are celebrating the idea that because they, barely control the state legislatures and the governors, that they can just, restrict voting willy-nilly. And I'm so proud. One of the other reasons I'm so optimistic, seeing the corporate community, people like Ken Frazier, the CEO of Merck, stand up and say, that isn't America. That's not how we're going to behave. And we're going to put our corporate muscle behind it. I think that is such an important development. And again, not something I would have seen a couple of years ago. I mean, it's easy to stand up and, file a brief in the Supreme Court about marriage equality. I mean, I don't mean to say it's easy, but it's relatively easy compared to what companies are doing right now, and saying, this is a really big deal to us, and your economy is going to suffer if you continue to discriminate. So I think that's all great, but I do think at the end of the day, we do need a new Voting Rights Act, that, whether it's HR 1 or the John Lewis Voting Rights Act, whatever it is. We need something in place that says we're not going to just leave this to individual jurisdictions to decide, because the whole idea behind the 65 Act was there's any number of nefarious ways to discriminate in voting, things that don't look like that big a deal, like you close a polling place an hour earlier, or you move a polling place the week before the election, or something like that. Well, they look formally neutral, that it affects African Americans and whites the same if you move a polling place, but it doesn't actually, because it's where that polling place was and where it is being moved to, and all sorts of things. So I think all of this needs to be looked at, and I really do want by this summer some sort of Voting Rights Act passed, because this again shouldn't be something that creates so much disagreement. I mean, just let people vote, and obviously if there's real voting fraud going on, it's going to get that punish that. But so far every study has shown that voting fraud is much more in the minds of various legislators who just want to enact voting restrictions than it is based in reality.
It is my understanding that part of the record in the Arizona cases pending at the Supreme Court includes the fact that the poll locations were moved frequently in minority precincts, and especially right along borders and so forth. So some of that may be part of the next case that is decided by the court. Okay, so let's turn to the big lie and the 2020 election cycle, and the allegations, the statements that were made without any supporting evidence in the lawsuits about how Trump really won, and Biden's election was a fraud. In the Dominion cases, the ones with the Dominion voting systems, it's my understanding that Sidney Powell, one of President Trump's lawyers, has argued that no reasonable listener would have believed me. This is just completely incredible. Wholly apart from.
It's the first time I've ever agreed with her, but yes, in a way.
So, do you think that defamation suits are a legitimate strategy? Is this something that might just work to flush this out?
I think it might work for Dominion because they are a company that have been surgically harmed in a way that, not everyone, it's not like some generalized grievance against the Democratic Party or Biden or something like that. This is a very specific set of allegations brought by a particular company and brought with specificity against, an individual. So I do think that there is something there. I also think the discovery will be enormously interesting. You won't be able to get some of it because of attorney-client privilege, of course, but there will probably be other parts of it that will be gettable. And look, at the end of this, though, I think, fine, Dominion goes after, maybe it wins its lawsuit there. That doesn't really get at, I think, the problem here. And I don't think it's a lawsuit problem. I don't think it's a civil remedy problem. I think it's something much more basic, which is like, can we tolerate this behavior from our leader, from the commander-in-chief? And I think that historians will look back on that second impeachment vote and those people who voted to acquit Trump. I don't think they go down well in history because if you can't
what do we do with what do we do with the fact that a majority of Republicans now believe that the election really was stolen?
I think that we have
but they believe that.
Yeah, that's a long-term problem. And it's going to require a long-term solution. So I think over time, the history and records will get built, and it will be shown, and that will move a certain number of people. But I think instead of fighting the last war about the last election, what matters to me is the next one, is inoculating our democracy against this form of vicious attack, which I think is every bit as dangerous as the attacks that the Soviet Union levied on America during the Cold War. And so to me, one solution is civics, is to really teach our kids what our founding values are. And this isn't just lip service. This is going to be like the next big thing I do, which is like figure out ways to reach children in school curriculums so that they can, understand fact and fiction, understand what our principles are. And then when they see a leader misbehave, I don't care, you can be the most diehard Democrat, but if a Democratic president says that same nonsense, absolutely impeach the person, 100%. Shouldn't be about politics. And I don't think that's an impossible goal. I just think it's going to take time.
So speaking of schools, many of the students in our Justice Studies program and the School of Social Transformation are interested in law school and being a lawyer using law to pursue justice. Can you share with us what you tell your students at Georgetown about possibilities and limits of turning to law to really advocate for justice and social change?
Well, it's such a privilege to be a lawyer. And just to make it incredibly concrete, my first Supreme Court case was Guantanamo. I represented Osama bin Laden's driver. And I was teaching at Georgetown. I was known as a national security hawk from my time at the Justice Department. But I saw what President Bush did in setting up basically a legal black hole at Guantanamo in which people could be put to death with no federal court review whatsoever in military tribunals that he fully created on his own. And I said to myself, this just can't be the United States of America. This just can't be what we are about. And I was a law professor. And so like I did what law professors do, which is like I testified in Congress and said that. I wrote a law review article with Larry Tribe. We rushed it to the Yale Law Journal saying this is unconstitutional and so on. Nobody read it. I mean, maybe my mom read it. I don't know, but nobody read it. And because that wasn't enough. And then I realized, hey, I am a lawyer. I hadn't really done any cases really to speak of. But I do have this thing called a law degree, and I am admitted to the bar. So I can walk in and sue the president of the United States. And that's what I did with virtually no experience or resources or anything else. So that's the power of this thing, this law degree. I mean, it's immense. It's also a privilege that can be abused, as the example you were just talking about a moment ago about another lawyer demonstrates. And so I think it's got to be done. I don't like the idea that lawyers are criticized for representing their clients. And I believe that very strongly. And in every case, no matter how heated the stakes are, and they've been very heated. I don't begrudge a lawyer for doing the job of trying to be the best advocate they can for their client. Obviously, if they do something unethical or something, that's a different matter. But in terms of zealous advocacy, the system is based on that. And so I think we want to celebrate that in our system. So, and I know it's hard. I know you see a lawyer that, saying stuff you fundamentally disagree with to your core, but that's how the system works. So I do think that it's an enormous privilege to be a lawyer in this country, and it gives you an immense set of tools and powers, and they should be used, responsibly and carefully and zealously.
So let me ask you another question that follows up on being a lawyer and how you go about being the excellent lawyer that you have become. You need to prepare, the academics and as well as the courtroom lawyers prepare lectures, they field questions. How do you prepare to argue before the Supreme Court?
I do it this.
Go ahead.
Sorry, did you say what you want to say?
I was thinking for preparation for my little case that Nina Totenberg did not attend. It was very small, but I did 3 moot courts, and really spent like 500 hours preparing for this argument. So how do you prepare and how do you present your cases?
Yeah, so I do the same thing that I've done I just did my 44th, and I do them all the same way, which is I sit down, I read all the briefs, I take notes on them, and then I create a binder with every issue in it and every answer written out to every question, organized topically. I then make a 2-page cheat sheet that is on top of the binder that has just a few words about any major question or something like that. And I then go and do my first moot court, and I do a lot of moot courts. I did 15 moot courts for my first Supreme Court argument.
Wow.
I still tend to do like 6. And like in the travel ban, the Muslim ban case, I think I probably did 10 or 11. It's for me, like, I don't think I'm such a good lawyer, but I do think I'm good at aggregating a bunch of smart insights from other people and taking them and learning from them and making the product so that when I stand up at the podium, it's truly the product of the team that I have working on it. And the best way of doing that is to moot the thing over and over again. And you don't want, obviously, the oral argument to sound like a committee report, like we were talking about earlier in your first question, in which it's got something for everyone. It's got to have one coherent theme. And so one of the risks of this kind of approach is that by taking too much from too many different people, you can lose the theme. So, I'm relentlessly focused on every insight I can get, small or big, from my team. And honestly, the insight can come from anywhere. Yeah, I have like all these bazillion people who've clerked on the Supreme Court working for me. But I have these paralegals who never went to law school who are every bit as brilliant and will give me insights that I will use regularly in Supreme Court arguments. So, I don't think that it's always about experience or credentials. I definitely believe much more in a kind of Google model, like decentralized, bottom up. Like you can get a lot, if you can aggregate a lot of insights from a lot of people, that's better than just getting a couple insights. You're getting fewer insights from, a fewer number of people. So I'll do all of that. And then the night before the argument, and I've done this now for 15 plus years, I go and I talk to my kids about the argument. And when they were really little, they were bored out of their minds, I'm sure. But to have to explain it to a little kid, particularly if it's something intricate and statutory, that kind of focuses a little bit of your attention on what's my theme, what's my main point. And now as they're older, it's a much more involved conversation. But I think still the practice of doing that to people who don't know anything about the case, don't know anything really about law, is, I think, an enormously helpful one. And then I get up in the morning and I listen to usually like my latest moot on audio, about 2 hours before the argument. And then I go and do it. And the truth is, I'm still get quite nervous before every argument, and I also I always think about my parents when I go up there, and just think about how lucky I am, what this country has given me. My parents came here from another country, and here I am. I'm arguing in the Supreme Court of the United States. That's like just such a privilege. I know. I'm sure you felt it when you argued the Hall case. It's just like, it's what democracy is at its best. I get to go in and argue something. I get to, go say President Bush violated the Constitution on behalf of a Guantanamo detainee, on behalf of bin Laden's driver. Like in many other countries, the driver would have been shot for bringing a case against the nation's leader. And more to the point for me, his lawyer would have been shot. But in this country, we say, no, you get to go bring your case, and indeed got to win it. So, I just think it's such a lovely thing about our system.
It's an enormous privilege. I do have to say, I did the same with my kids. On the day before the argument, we walked around the monuments in Washington, D.C. and questions. They asked questions. I gave them answers, and it helped. It did help. Okay, so let's talk about your media and digital presence. That's a big part of your career. At this point, you've launched 2 digital series. You appear regularly on news shows. Who's your audience generally, and how do you approach them? What kind of advice do you have for people who want to follow in your footsteps in terms of doing media work and bringing a critical view of important issues relating to social justice to the public domain?
Yeah, it's such a great question, and nobody's ever asked me that before. So, let me, this may not be as polished as I'd like, but I didn't start out doing media stuff at all, really, and didn't until Trump won the election in 2016. When he won, I felt like a fundamental commitment to go in every forum I could and explain why what he was doing was so corrosive. And so that involved litigating, things like the travel ban, and, setting up my whole center at Georgetown, the Institute for Constitutional Advocacy, to have lawyers bring cases. But I knew that court cases alone weren't enough, that the nation needed some education about kind of basic constitutional principles. And so I started to do TV from that premise. And then ultimately I was doing CNN and MSNBC every night for like a year, both. And I was just exhausted. So finally I just picked one network, and MSNBC. And and started doing just those shows. It's again been an enormous privilege to be able to talk to a couple million people at night and give my views on something. And at the same time, it's balkanized. It's only that segment of the population that watches news and watches MSNBC, and that isn't where I want to be. And so that's why my next endeavor is going to be to speak really to everyone, not in a political way, but to go and teach these foundational values about what truly makes America great, and to tell stories about our Constitution. I mean, there's so many phenomenal things, little nooks and crannies.
How will you find that audience? How will you determine or I guess reach the young people and the
stay tuned. I got a plan, but it's not out yet. But I got a plan, and
all right, good.
And it involves a lot of humor. And I got some funny people, but it also involves really, I've been for the last 5 years, I've been sitting there thinking to myself, what are interesting stories about the Constitution that aren't going to bore people and bore kids, that'll really teach them what the thing's about, whether it's free speech or the Fourth Amendment or who gets to marry who or whatever. There are phenomenal, just great inspirational things. And so I've started to collect all those. And that's the kind of idea that I have, which is, yes, I'm a law professor. Yes, I'm a Supreme Court advocate. I didn't ever anticipate I'd be doing mass outreach, but I kind of feel like we all need to step up and do that right now. That we're in a crisis of our democracy, in which, things that should be off the table, like who can vote and restrictions like that, or the nonsense that Tucker Carlson's been spewing about immigration, like those things are, just they're so easy for someone who understands American history to laugh at and to reject. But people don't have the tools yet, and so we need to give them to them.
So I understand we have quite a few questions from the audience. So let's turn to those now. Professor LaDawn Haglund is going to present those to us. LaDawn?
Good evening. Will you give me a thumbs up if you can hear me? Excellent. So I wanted to channel a couple of the questions about the international realm to you. You're a partner in a global law firm, and being myself somebody who studies international human rights, there's some consternation that the US courts don't pay that much attention to US law. And I wanted to know if you could give us a sense of how the courts are embracing or rejecting international legal standards and why it matters. And maybe you could bring in examples from asylum or other kinds of questions.
Yeah, I mean, I do think that there's a pretty deep reluctance on the Supreme Court to take, international law that hasn't been expressly bought into by the United States and to use those governing principles, for better or worse. I think that that's right. But the flip side of that is, if you've got something in international law that has been acceded to by the United States, then that is something that does bind. So, for example, in that first Guantanamo case, one of the arguments I made about Guantanamo was that it violated Common Article 3 of the Geneva Conventions, which guarantees the rights indispensable to all civilized peoples to tribunals that mete out justice. And the Bush administration said exactly like your question. They said, oh, we're not bound by international law. We can do what we want. We're the president, blah, blah, blah. And I said, nope, this is ratified by the Senate of the United States. It is United States law. And indeed, the Supremacy Clause actually, has treaties in it. So, as part of it. And so the Supreme Court did apply Common Article 3 of the Geneva Conventions in that case. So to me, the question is a little bit less about, whether international law, could bind the courts. And I think instead we need to focus more on getting the Senate to ratify treaties and international protocols and bring international standards directly into the laws of the United States. And so to me, that it's a political problem more than it is a judicial problem.
Wonderful, thank you. Several of the questions that have come through are probing a little bit more about the Supreme Court. And I wanted to ask, first of all, you've mentioned and you talked about how the Supreme Court has become rather political, or seems to be rather politicized, and in terms of appointments especially, unlike in the past. And so I'm wondering, or someone is wondering anyway, whether President Biden would potentially have an opportunity to appoint someone new. Do you foresee anybody leaving the Supreme Court? There's opposition from Arizona Senator Sinema to changing the filibuster. So do you see movement in that area?
I mean, I just know what everyone else knows. Statistically, there's a probability that there's going to be a vacancy at some point in the next 4 years. I clerked for Justice Breyer. I've seen all these articles, urging him to retire. I find them distasteful. I think that Justice Breyer is going to do what Justice Breyer thinks is right, and he's an enormously publicly minded person. I don't know what's going to happen. I do know that some of the people that are being talked about as potential new nominees to the Supreme Court, or should a vacancy arise, are pretty extraordinary. One that I'll just mention briefly is Leandra Kruger, because she was my deputy solicitor general when I ran the office. She's now on the California Supreme Court. And she's definitely among the top handful of lawyers I've ever worked with. Just extraordinary. So I am, and I think there are others too. Ketanji Brown Jackson, another one, phenomenal, just great. So there's a good group of people that President Biden has should a vacancy arise. And these are people who I think are just of enormous credibility and stature, who are good listeners. Your question, made it sound like I'm saying the court is politicized, or part of that question, and that isn't what I'm saying. I do think the nomination process has become politicized, but I don't think that justices go in after hearing an oral argument and are like, oh, I need to vote for this side or that side because of politics in any way. And the best example of this is, President Trump's tax returns case, in which, Trump made a whole big deal of going to the Supreme Court so that the Manhattan district attorney couldn't get his tax returns. Trump lost it unanimously at the Supreme Court. His own appointees voted against him, because I think there's a commitment to the rule of law. That's not to say like every single decision I'm going to agree with from the Supreme Court, but I think it's a mistake when we think about the Supreme Court in strictly political terms, because they do operate in a different way. And there's lots of other examples. The census case from the year before, in which the Supreme Court 5-4 said, President Trump, your cabinet lied about the census and adding that citizenship question to it. DACA, another one. So, there's a bunch of things.
Great, thank you for that clarification. Do you see the Supreme Court impacting movements for social justice in the coming years, like from LGBTQ rights to voting rights to civil rights? What's your prognosis?
Yes, I do. There's a complicated interrelationship between movements and Supreme Court decisions. And, there are all sorts of books written about it, like The Hollow Hope by, I think, Gerald Rosenberg, people like that. One, like marriage equality is a good example, in a case in which I do think the popular attention to the issue did ultimately influence the Supreme Court. I had the privilege of working on that case with all these phenomenal lawyers, and they, saw this, a decade before the public. But I do feel like public perception of marriage equality changing did influence the court. If you were to ask me in 1996 when I clerked at the court, or 10 years later, do I think the Supreme Court 10 years after that is going to strike down all these laws that limit marriage to one man and one woman and declare marriage equality? I would have said, no way. Well, I was wrong. I mean, and these phenomenal lawyers who were working for marriage equality for decades, they were right. And it was, probably the most moving experience of my life to be in court that day, to hear Obergefell come down. And, before I walked into the court, we didn't know the decision was going to come down that day. It was the second to last day or the third to last day of the term. But so when we walked into the court, there were like 100 pro-marriage equality people with their signs and like 100 protesters against it. It was just like a small, peaceful protest, no big deal. And, then we're in there, and the Chief Justice says, Justice Kennedy has the opinion for the court in Obergefell. And for several minutes, Justice Kennedy read the opinion, but just like the facts, and it was all just so dry, and we're like, oh, and it sounded like we lost, and so we're like crying and like very sad. And then all of a sudden, he has pages about how the tradition of marriage in Western civilization is between one man and one woman. He's going on about this, and we're like, oh no, this is horrible. And then he says, but the tradition doesn't stop there. And he pauses, and then it's like all about equality and about how discriminatory these state laws are. And when we walked out of the court, half an hour later, there were tens of thousands of people on the Supreme Court plaza with their arms linked and singing America the Beautiful and all sorts of stuff. And I've never seen anything like it. And I don't have the words to describe how we felt in that moment and what we were witnessing. But that was an example in which the movement preceded the court litigation. Now,
is the same with respect to the trend toward racial justice and social justice and your optimism toward that movement that you were speaking about before?
Exactly. So I do think that as society develops a greater consensus around racial justice, I do think that's going to influence the court. And Susan's such a great way to draw the connection in exactly the same way. So I feel more optimistic there. Less optimistic, I'm someone who cares a lot about reproductive rights. I'm very worried about where the court is going in that direction, and what kind of social movements, to return to the question, are going to be unleashed as a result of Supreme Court decisions that bless restrictions on abortion and the like. So, I'm an optimist on some things, but not all.
What a great story. Thank you so much for sharing that. Well, let's move then to questions about civil society and the public. Non-governmental organizations and faculty, scholars have been involved in Amicus briefs. And this is a place where social science research and law meet up. Can you discuss the role of Amicus briefs, their evolution or influence within both the Supreme Court and our legal system, and their importance?
Yeah, so for the non-lawyers, an amicus brief is a friend of the court brief, and it can be written by any interested individual or organization. You can be a professor, you could be a company, you could be an NGO, whatever. And the truth is, most amicus briefs are pretty irrelevant, I think. I don't even think many of them get read, and they shouldn't get read. They're often more about fundraising for the organization, so they can say, we filed a brief in case X, than they are about actually trying to give the court a distinct perspective. If you do that, though, if you give the court a distinct perspective, it really matters. In like the affirmative action cases, there was a brief filed by former military officers talking about the importance of diversity for our military. that I think was enormously important, and there's lots of other examples like that in which if you can provide a distinct perspective, it really does matter. Marriage equality, I do think the fact that all those companies stood up for it mattered. I said, as we were talking about an hour ago, I said it's not quite as much as being out on a limb as what Merck and others are doing right now, but still, I do think those things influence. And I have to say, the place in which I think that friend of the court briefs matter the most is not after the Supreme Court agrees to hear a case. It's in their decision about whether to take a case at all. So the Supreme Court gets about 10,000 requests a year to hear a case, and they only hear about 65 of them. So it's like way easier to get into Stanford or something than it is to get your case heard by the Supreme Court. It's really, really hard. And one of the things they're doing, the justices, when they're trying to decide whether to take a case, is they are looking, how important is this in the real world? And so if you're an amicus that can say, look, it's, this Jones versus Janes case, Jones believes one thing, Janes believes another. We're not Jones, we're not Janes. We don't have any stake in this directly in this particular case. We do have a stake in the issue. Supreme Court, we want you to resolve it, because here's practically what happens if you don't resolve it. That's really important. Those briefs matter a lot to the court, because then they're not just getting the self-interested views of two parties that to the litigation, but some outsider perspective. So that's that, and so I tend to really only file those amicus briefs. I don't tend to do the others. Again, there are exceptions, and sometimes when the lawyers for a particular client aren't so great, which, for example, unfortunately happens in some death penalty cases and the like, that's one in which, as an amicus, you can marshal the arguments and facts that maybe the lawyer for the client wasn't able to.
That ties into another question that was asked about evidence-based policies and decision-making. And it's kind of a specific question, but maybe you can shed some light on the kinds of data that the public needs in order to be effective advocates for change, either in the legal system or with regard to particular cases, whether it's detention centers or prisons.
Well, I think the most important thing is actually to read the opinions. So directly, the great thing about our court system is they've got to tell you what they think. They got to show their work. They can't just make a decision in general. There are some exceptions to this, but for the most part, when courts make decisions, they have written opinions for you and me to read, and then we can critique their reasoning. And one of the things, unfortunately, is that journalists, they don't get it right oftentimes, and they make it too simple. And there's no substitute for going and reading the real thing. Particularly right now in the Supreme Court, you've got a number of justices who are actually trying to write for the public. There are no footnotes. They're trying to write in normal English and not legalese and the like. And so particularly if it's a Supreme Court decision that you are reading about and you say, God, that doesn't sound right, or boy, that sounds amazing, go and look it up and see. And if you want to take it one step further, if you want to just experience the drama of the Supreme Court, every oral argument is online and you can listen to all of them. They're on a website called oyez.org. It's oyez.org. And you can listen to Thurgood Marshall arguing Brown versus Board of Education, or Susan arguing her Hall bankruptcy case. And so that's really can give you a nice perspective about the way in which the court truly operates.
Great, that's very helpful. This next question also is about non-lawyers. It's in reference to the Cisco Cast case, where California regulators recently sued Cisco Systems, accusing it of discriminating against Indian American employee, an employee, for allowing him to be harassed by two managers because he was from a lower caste in India. And the question is, what do you think are the most viable paths for activists to bring this kind of a argument or a case into other anti-discrimination.
Yeah, sorry, I don't know anything about that case, so I'm not going to talk about that one.
Okay, all right. In that case, is there a particular amendment to the Constitution that you think is needed today?
Well, probably a bunch, but one thing that I do think is I like the idea of moving to 18-year Supreme Court terms for justices. That's the historical average that justices have served. I think, it could only be done, or really should only be done on a going forward basis, not for the existing court, but, as we move forward in time, I think I like the idea of 18-year terms. It's otherwise you get into this weird spectacle of, kind of figuring out people's health and the like, and, these distasteful op-eds that I mentioned before. So that's one. I think it could be, that could be a pretty great amendment.
Pretty unlikely it would pass, however.
Well, I don't know. I mean, it might, or maybe you do it behind the veil of ignorance before the next presidential election. I understand, like, if you did it right now, it would hurt Biden in ways that Trump and, his predecessors weren't bound by. So, maybe you do it starting in a few years.
LaDon, I think we're getting close to an hour and a half, so maybe just one or two more questions. Can you choose remaining questions here?
Yeah, sure. So I want to end with a particular question, but I want to ask one more before that. And this is about restorative justice. Do you have any view on what a restorative justice model for addressing a range of harms might be, whether it would be beneficial, what the obstacles might be? Anything from environmental degradation to racism to indigenous issues?
Well, I don't think I have anything particularly unique or insightful to say on that, except to say that I did read Martha Minow's book about the South African Truth and Reconciliation Commissions, which I found pretty extraordinary. And I do think, there's a tendency for us litigators to always want to duke stuff out in court. And that isn't the right model sometimes. Sometimes the right model is just listening and uncovering truths and letting those truths, by being uncovered, do the work. That you don't need a judge to say one side is right and wrong. Sometimes that answer becomes obvious over time. And so, that's a model that I think could be used in some places. Having said that, like there are serious environmental crimes that have gone on. There are serious crimes on the basis of race that have gone on. And I don't want, some skim milk version of justice for those things. I want, true justice to happen. And that will require litigation and will require court decisions.
Okay, so the final question then what are some important steps to getting more Black, Indigenous, people of color on the pathway to the bench? And what advice would you give for a student who wants to follow in your footsteps? How did you get where you are? What should they do to prepare? That sort of thing.
Yeah, what a lovely set of questions. I do think we are moving to a country where we are concerned more about diversity on the bench. I certainly don't think that the bench is the only place in which lawyers can make their mark. And so, I don't think it's right if you're like in law school or thinking about going to law school to say, I got to be a judge, because there's so many ways to make the world better as a lawyer. But I mean, I do think my experience was that I didn't plan to be here at all. I planned on being a professor. And I stood up for a cause I really believed in, Guantanamo. And everyone thought I was crazy to take that on, bin Laden's driver. But I felt like it was the thing we are supposed to do as lawyers, and the thing I felt called to do. And when I won that, it opened a lot of different doors for me. But the thing that allowed me to do it was that it was actually a pro bono thing. So like I was able to go, I didn't have to like fight 50 established lawyers to represent a Guantanamo detainee. Nobody at that point wanted to. So, and I do think that's true about pro bono litigation in general. So I would say, like, if you're, right when you get out of law school, look for a pro bono case, look for that opportunity, both because it'll make the world better, but also because it's going to give you some valuable experience. And keep looking for those opportunities. So that's number one. Number two is, I think you've got to work for a place that allows you to be in court if you want to be a litigator or be on the bench. There are many places in which you'll just be stuck in an office writing memos for year after year. And that's true even in public interest law too. It's not just, something about the private sector. So I think that's a really important, is to figure out where you can get experience to be a full-fledged attorney, not just working on a piece or a part of a case. And then number three, the most important piece is having mentors. And, I can just tell you that you sometimes have to be a squeaky wheel. People are busy, particularly the best mentors are busy, and you got to bug them. And, I wouldn't be here if it weren't for a couple of mentors that I had. One that I just randomly got assigned in law school in my first day at Kiel Lamar, and others too. And, as we get older, the thing that we've got is who our mentees are. That's like what I take so much pride in. And so it's not like you're just helping yourself when you seek out a mentor, you're also helping us. And, it's something that we take seriously too. And it gives us immense joy. So I work hard at pursuing that, figure out who speaks to you, who speaks to your heart, and go after her or him.
Thank you, Neal. Thank you so much for sharing your insights, your very thoughtful perspective. Gretchen, you were right. Neal is indeed the right scholar and advocate and fighter for social justice that we need so badly right now in America. Neal, I look forward to your civics lessons and applaud your initiative to undertake that very critical role. John Frank would have been honored to know you, and so pleased that you're our lecturer tonight. So let me turn this back to Professor Haglund to conclude our event.
I'm LaDawn Haglund, Faculty Lead for Justice and Social Inquiry. On behalf of all the staff, students, and faculty in the School of Social Transformation, we want to thank you for attending the 2021 John P. Frank Memorial Lecture with Neal Katyal. We're grateful to Louis Rocha, partner, and John Frank's former colleague, Susan Freeman, for hosting this evening's conversation. We welcome you to learn more about and help sustain this annual event by visiting our website. You can search key terms School of Social Transformation and Frank Lecture. Good evening, and see you at the 2022 John P. Frank Lecture or at another School of Social Transformation event.